In this segment, I want to talk to you about the kinds of decisions that are made by the U.S. Supreme Court and the kinds of appointments that are made to the Supreme Court, and try to explain in the final segment what the problems are that have occurred in the Supreme Court that stem actually from the very first, or one of the very first topics we talked about, the nature of the rule of law and the decline in the quality of the rule of law that we have in this country. First of all, let's take a look at the Supreme Court. What does the Supreme Court do? It's only going to take those cases it wants to hear. There's no way to force them to hear cases they're not interested in listening to. They just won't do it. And there's no higher court to appeal to. So if the Supreme Court doesn't give you a writ of certiorari, or if it doesn't grant cert, your case is finished. It's finished at whatever the decision was at the Court of Appeals level. If, however, they took cert, if they grant cert and accept the writ of certiorari, you're getting a hearing before the Supreme Court. That hearing before the Supreme Court will come after the Supreme Court has reviewed all of the pleadings that they wish to review. Do they review all of them? I have no way of knowing. Neither does anybody else except the justices in the room. They are the last stop for the bus, and therefore there's no one to appeal higher. But in the belief that they do review most of the relevant parts of whatever they're sent from the lower court, they're also going to have a meeting in chambers in which only the justices are present. No aides, no secretaries, just the 9 justices discussing the case. We don't know exactly what goes on, but we've been given some hints, given some information, and we know this. The most junior member on the court is in charge of opening the door to see if they need notes or something from outside, and closing the door to make sure no one else gets in. And when discussing the case, the most junior member speaks first, discussing the case as he sees it, and discussing the outcome and the reasons for the outcome that he sees. They go around the court, most junior to most senior, and then they have a more open discussion about it. It is true that sometimes in conference, the decisions that a justice takes in conference is not the position he takes in the final. He changes his mind, and he has every right to do so. He or she has every right to do so. After conference, they go back and deliberate. They circulate drafts of proposed statements. It is the prerogative of the Chief Justice to appoint the writer of the majority opinion, assuming there is a majority opinion, or the plurality opinion, if that's what it turns out to be. And then individuals are free to decide their own concurring and dissenting opinions. Then, that's at that stage, and before they finalize everything, they have a hearing, an oral hearing in which lawyers come in and argue their case. They get about an hour, so 30 minutes to make the most pointed points they can make about their case, all the while being threatened and often confronted by questions from the bench. And then the final deliberations leading to the end result. What do those end results look like? Well, the end results come in the following form. If the court chooses not to give you any reasons at all, they may give a per curiam decision, a simple decision in which they say they've decided the outcome of the case, A won, B lost, but they don't give any reasons. Or if they give a reason, they give less than a paragraph worth of perfunctory statements about why they have chosen to give a decision without, giving a judgment without giving a written decision. A per curiam decision is exactly the kind of decision that the original Supreme Court, before John Marshall, chose to give. They had serial opinions. Each justice who wished to write an opinion wrote an opinion. And the problem was that you'd have an outcome, like 4 voted one way and 1 voted the other way, 3 voted one way, 2 voted the other way. The early court was not a large court. but you had no way of knowing what the reasoning of the court was except to add up the opinions of the various writers of the serial opinions. Now this made the delivery of the rule of law very complicated. It meant that you never quite knew what the court had decided, and that flies in the face of a basic principle of the rule of law, which says the law should be knowable. You're not going to get a knowable opinion if you have serial opinions. And this realization on the part of John Marshall led him to take a decisive step of urging the court to begin to issue single opinions. If they were unanimous in their vote, he wanted one opinion, and that's all. If he did have a divided court, a majority in favor of, he wanted a majority opinion, and then whoever dissented could dissent. But he wanted the court to speak with one voice. Now, he didn't always get it. And today, it's increasingly uncommon for the court to be unanimous, or for the court to speak with one voice in a majority opinion. Instead of getting a majority opinion and dissenting opinions, today we get a great many plurality opinions. That's a situation in which the case is decided 5-4, perhaps, but maybe only 3 justices agree on the reasons. The other 2 who voted to decide the case one way will give a concurring opinion. They concur in the decision of the court, but not in the reasoning. And then, in the most extreme case, the plurality opinion may turn out to be just 2 justices, the only 2 that could agree on anything, and then 3 concurring opinions. And then, of course, on the other side, there'll be dissenting opinions, to which members who are in dissent can also concur. This leads to very complicated decisions, and indeed, in the 21st century, we get an enormous number of extremely complicated decisions. Decisions where someone in dissent concurs in part of the reasoning, though they didn't decide to vote with the majority to decide the case. And in which some of the concurring opinions on the majority side sound like they agreed with the dissenters in some respects. In short, we have moved to a situation in which the court responds increasingly like the very oldest Supreme Court did, with serial opinions. And we're the losers. The nation as a whole loses when it doesn't get a clear decision from the court. If the court does not come up with a clear decision, that means the courts of appeals, who are counting on getting guidance from the Supreme Court to make it uniform across the nation, they're at a loss. They don't know what it means because the court didn't tell them what it means. And if the Court of Appeals doesn't know, then certainly all of the wide number of district courts don't know what. Oh, but then that's not enough. Neither does the U.S. Attorney, who works with each of the district courts deciding what to prosecute or what to represent, should it be that the United States is being sued. But then, of course, the defense attorneys, or the defense attorneys, whether it's civil or criminal, they don't know what the law means. But then, if they don't know, how does any lawyer know? And indeed, that's the problem with unclear decisions. Now, why are there unclear decisions? Well, one of the jobs of the Supreme Court is not just to interpret whether a law contradicts the U.S. Constitution. They also have the responsibility to interpret what the law itself means. One form of judicial review, the most basic form of judicial review, is simply to ascertain the meaning of what the legislature has passed. And sometimes that's a very difficult task. Why? Well, but the legislature has stopped passing clear laws. They're into delegating power and trying to make their opinions as palatable as they can to everyone. And so they write them in a vague way, intending that it mean one thing to one group and one thing to another group, and satisfy everybody along the way. So, there's a serious problem with the kind of laws that are passed. And, by the way, let's not leave the president out of it. The president has signed any law that's gone into effect. He may rarely veto a law, and may have passed over it, but fundamentally, if a law passes the Congress, if a bill passes the Congress in identical form, goes to the president, and he signs it, it becomes a law, and nearly every law is in that way. So the Congress and the president have let us down by passing unclear laws. That leaves it to the courts to interpret unclear laws, and guess what? They don't want to take the heat either. They want to take it, so they pass it over by making the most minimal kinds of decisions they can in response to a vague law and giving a vague decision in response. It is this weakness in our commitment to the rule of law that weakens the court. Increasingly, then you hear the criticism that the courts are acting like a legislative committee, that they're making decisions, that they are deciding what the law means. Yeah, that's exactly what they're doing. Why? Well, because they were given a vague law to start with. So somebody has to decide what it means, and when they decide what it means, when they interpret it, they end up making law. Now that's always been true. Courts have always had an interpretive function, and there's always a sense in which the court, when it interprets, is, quote, making law, unquote. So to say this is all the responsibility of the most recent court would be wrong. But what is new in the current court and in the court in the recent past is the extent to which they are required to legislate simply to give clarity to the law. And the more they do so, the more they make it likely that the Congress will duck its responsibility by saying, well, we're going to pass this law in this form. It may not be constitutional, but who cares, because the federal courts will tell us whether it's constitutional or not, and they will let us off the hook. We will have voted in a way that we think is compelling for our constituents, so they'll vote to re-elect us. And we'll let someone else worry about whether it actually goes into effect or it serves the purpose that it purports to do. This has led to the final problem in terms of the appointment of the Supreme Court. If we in fact have the 9 members of the Supreme Court acting as a legislative committee writing laws, then they become the lawgivers. Not just the law interpreters, the lawgivers. And as such, they become principal political leaders. That is what has made the current appointment process for the Supreme Court so contentious. There have always been some controversies over it, and they go back a long ways. But in the modern age, which I date from the appointment that Ronald Reagan made of Robert Bork to the court, from that point on, all of the appointments to the Supreme Court have had a potential for a great deal of controversy. Some have had less controversy, but that's only because the people who were appointed had absolutely no record that they could go on. So the hearings that were held had them saying platitudes, saying that they couldn't announce their decision on cases they hadn't heard yet, that was unprofessional, which is a true statement. But it is a true statement that leaves us without any knowledge of what those people might do when they get on the court. We face a very difficult situation. The weakness in the laws that are passed by Congress and signed by the President leads to a weakness in the court decision, and that in turn leads to the politicization of the court, which is very dangerous. I'll take up the entire issue in the final segment.